I'd like to introduce today's speakers, Kelsey Knudsen and Margaret Hansen from Davis Brown Law Firm. Kelsey joined Davis Brown Law Firm in August of 2013 as an associate attorney. She is a member of the firm's litigation division. Kelsey currently serves as a District 5C representative for the Iowa State Bar Young Lawyers Division. Maggie joined the Davis Brown Law Firm in August of 2013 as associate attorney. She is a member of the firm's litigation division also and maintains a general litigation practice. I will turn it over to Maggie and Kelsey.
Thank you. This is Maggie Hansen speaking first. I'm just going to do a brief introduction, and then Kelsey will go into the discovery amendments. The Iowa Civil Justice Reform Task was formed. It was an 84-member task force, and it compiled a report in 2012. And based on that report, the Supreme Court formed a 14-person Civil Justice Advisory Committee. That Civil Justice Advisory Committee, like I said, was formed in fall of 2012. And this was comprised of judges, attorneys, and civil procedure professors. And they had 6 meetings from November 2012 to July 2013. They presented their proposals on November 1st of 2013, and the public comment period was open from November 2013 to March of 2014. This Civil Justice Advisory Committee gave certain recommendations. Those recommendations first were that discovery amendments should be made for all cases. Second, they recommended a new expedited civil action track, which would create a track for cases seeking $75,000 or less in monetary damages. And thirdly, they recommended a care provider statement, which is admissible in lieu of physician testimony in those expedited cases. On August 28th of 2014, the Supreme Court filed an order, and they largely adopted the recommendations made by that Civil Justice Advisory Committee. They adopted the expedited civil action track and all discovery amendments for cases filed after January 1st of 2015, and selected discovery amendments that would apply to pending cases on January 1st of 2015. The purpose of these amendments was to create a more efficient and more cost-effective discovery and litigation path for litigants. It was to create a streamlined and expedited litigation track for civil cases below that certain dollar threshold, which, as I said before, is $75,000. And the thinking behind this was that it would provide greater access to justice for those who may not be able to afford litigation, etc. So the final purpose for these amendments was to move toward the federal discovery rules. And as you'll see, these are very similar to the federal discovery rules if you've had any experience with federal litigation. But there are some variances, and we will point those out as we go along.
So as Maggie said, these amendments became effective January 1 of 2015. However, the bulleted items on this slide only become effective for newly commenced cases as of January 1, 2015. So today I will be discussing these changes, and specifically I'll be discussing the discovery conference and the new initial disclosure requirements. So those new changes will only take place if there's been a case that's been commenced after the turn of the new year. I want to begin by describing or discussing the cases that are exempt from the initial disclosure requirement. So all of these cases do not have to comply with that new rule. So as you can see, actions in FEDs, small claims proceedings, and uncontested domestic relations proceedings, uncontested foreclosure proceedings, etc. These are exempted from this initial disclosure requirement. Now I started with that slide, even though I want to begin by discussing the discovery conference, because any of those cases that are exempt from the initial disclosure requirement are also exempt from this discovery conference. So now, pursuant to the new rules, parties must engage in a discovery conference unless they are exempted on that slide that I previously showed you. And the discovery conference must be held no later than 21 days after any defendant has answered or appeared. So this means that if a plaintiff is suing multiple defendants and only served one defendant and has yet to serve the various other defendants, the plaintiff and that first defendant must engage in the discovery conference within 21 days after that first defendant has answered or appeared. Now, this discovery conference must take place regardless of any pre-answer motions, such as a motion to dismiss. It is the plaintiff's obligation to notify all of the parties of the discovery conference deadline. However, it is all of the parties' responsibility to contribute and participate in this discovery conference in good faith, including pro se litigants. Within 7 days of the discovery conference, the parties must file a Rule 23.5 Form 2 Trial Scheduling and Discovery Plan. This form is very detailed because at the discovery conference, the following must be discussed amongst the parties: the nature and basis of all claims and defenses, the possibilities of settlement. The parties must make or arrange for the initial disclosures. They must discuss how discovery will be preserved and how that information will be preserved, and they must then develop the discovery plan. So unless otherwise ordered by the court, the parties have to discuss in this Rule 23.5 form document the parties' views on the following. They must discuss any changes in timing, form, or the requirements for the initial disclosures. As I will be discussing here in a little bit, the parties can stipulate to other initial disclosure requirements. So if they want to have a longer time, or if they only want to exchange certain forms of information and not all of them, they can do that, and they'll have to state it in their discovery plan. The parties also must state the subjects on which discovery may be needed and when discovery should be completed, and if it will be conducted in phases or only on certain issues. So the parties have the ability to both agree that instead of serving 30 interrogatories, maybe only 20 is necessary in the type of case they have. So if that's the case, then they will need to state it in this new form document. The parties also have to discuss and state how they will address electronically stored information, such as how it will be preserved, disclosed, etc. And then if there are any issues about attorney-client privilege or work product privilege, they must also discuss that as well. As you can see, there are a lot of things that the parties must discuss. So if the parties cannot agree on any of these issues, then they will want to state that in the form document and include an attachment if necessary to identify any other information they think the court should be aware of. And they will also want to request a pretrial conference. At this conference, the court will then decide on how the discovery dispute should be resolved. So after this discovery conference has taken place, the initial disclosures are due within 14 days, unless the parties stipulate otherwise or the court orders otherwise. Also, if a party objects, perhaps a party doesn't believe that the initial disclosure requirements are appropriate in that case, maybe there's an issue about whether or not the particular case is exempt from the initial disclosure requirements, referring to that slide I showed you earlier, then the parties do not have to exchange their initial disclosure requirements or initial disclosures. They can wait until the court rules on that issue. So if any party is served or joined after the discovery conference deadline, then they must make their disclosures within 30 days of being served or joined. So referring back to my scenario where the plaintiff served one defendant and various other defendants were added, the defendants that were added at a later date get 30 days from when they were served or joined to make their initial disclosures. So there are 5 initial disclosure requirements, unless the parties stipulate otherwise. So the parties must exchange the identity and contact information for each individual likely to have discoverable information, along with the subjects of that information that the disclosing party may use to support its claims or defenses. The contact information includes the email addresses of each individual, and this information does not have to be provided if it will be only used for impeachment purposes. The parties also have to exchange all documents, including electronically stored information and tangible things that a party may use to support its claims or defenses. The copies of the actual documents must be produced unless a good cause reason exists for doing so. This rule has really moved from document identification to document production. In the past, we could just send a disk or identify the documents, but now we have to produce hard copies unless we have that good cause reason for not doing so. And if we do believe we have a good cause reason for not doing so, we have to describe the location of the documents and describe the documents as well as the name and address of the custodian of those documents. The third initial disclosure requirement is the parties have to exchange the computation of each category of economic damages. And this includes the documentation that they were relying on in order to compute the total amount of economic damages. This rule does not require that the parties exchange their disclosure on the exact dollar amount for non-economic damages. The fourth requirement is if an insurance company may be liable for all or part of a claim at issue, then the party will have to provide the declarations page of an insurance agreement. And lastly, the fifth requirement is if insurance coverage may be in dispute, the party will have to provide the insurance policies and letters from the insured to the insured regarding coverage. So these initial disclosure requirements must be provided based on any information that's reasonably available to the party. The rules in the commentary clearly indicate that the following are unacceptable excuses, saying that the party has not fully investigated the case, that the information is in the possession of the party's insurance carrier, or that the other side didn't provide their initial disclosures or didn't sufficiently do so. Those will not be acceptable excuses. So this is where the initial disclosure requirements deviate from the federal disclosure requirements. These rules carve out additional initial disclosure requirements for certain types of claims. So if a case involves a claim of personal or emotional injuries, in addition to those 5 initial disclosure requirements which I just walked through, the party that's bringing a claim of personal or an emotional injury must provide their full name and date of birth, their Medicare health insurance claim number, the names and addresses of all care providers they've consulted with 5 years prior to the date of injury up to the present date, and they must provide the other side with a legally sufficient waiver to allow that other party to obtain their care provider records. Whenever the other party relies on that waiver to access the records, they must notify the claimant and provide a copy of those documents, but they do not have to be hard copy documents unless the other party requests, and in that case, the party requesting that will have to pay for that form of getting those documents. Whenever a case involves a claim of lost time or earning capacity, in addition to those 5 initial disclosure requirements, the following must be provided by the party bringing this claim. The party must provide the federal and state income tax returns for the 5 years prior to the date of disclosure, the names and addresses for all employers for the 5 years prior to the date of disclosure, and they must provide a legally sufficient written waiver authorizing the other side to access their employment records and personnel files. Again, the other side has to give that contemporaneous notification when they're accessing those records, and does not have to provide hard copies of those documents, but may do so in electronic form unless the other party requests. In regards to domestic relations proceedings, in lieu of those 5 initial disclosure requirements, the following information must be exchanged between the parties. Their pay stubs or other documents showing income from all sources, all tax deductions and health insurance premiums, union dues, and mandatory pension withholdings for the past 6 months. If children are involved, the parties must provide a breakdown of the cost of an individual health insurance plan and the cost of a family plan. The parties must also exchange all tax returns for the 3 most recent years, if not already in the possession of the other party. Now, these first two are the only requirements that must take place for a modification action, but for non-modification actions, the parties must also exchange a current financial affidavit as well as any statements of accounts or other documentation supporting their assets and liabilities on their financial affidavit. Regarding expert disclosures, retained expert reports are due with the designation of experts unless the parties otherwise stipulate or are otherwise ordered by the court. The expert reports must contain a complete statement of all opinions the witness will express and the basis and reasons for them, the facts or data considered by the witness informing the opinions, the exhibits that will be used, the expert's qualifications, including past 10 years of publication, the last 4 years of cases where the expert provided testimony at a trial or a deposition, and the statement of the compensation to be paid to that expert. So this new rule will now take the place of the former interrogatory expert form answers that we previously used in the past. For experts that are not required to provide a report, such as treating care providers, the party calling that witness must disclose the subject matter on which the witness is expected to present evidence, as well as a summary of the facts and opinions to which the witness is expected to testify. The timing for these expert disclosures will normally be by court order, usually 90 days before trial or 30 days for rebuttal purposes before trial. The pretrial disclosures, this rule has changed. The biggest change is that pretrial disclosures must be made at least 14 days before trial. The federal rule requires that the pretrial disclosures take place 30 days before trial, and the former Iowa rule had 7 days before trial. This committee and the Iowa Supreme Court thought that 7 days was too short of a time, so now it's 14 days unless the parties otherwise stipulate, but the parties may not stipulate to a time period of less than 7 days. The discovery rules, they're subject to the timing and the rules regarding this new initial disclosure requirement. There are 2 new objectives to the discovery rules, and they are that the discovery be administered in a speedy and inexpensive manner. And one of the ways that is going to help cut down on the costs associated with discovery disputes is now when parties have a discovery dispute, they must actually reach out to the other side and personally speak with that person or attempt to personally speak with them either on the phone or in person. So before you can bring a motion to compel or a motion for a protective order, you have to certify in your motion that you have in good faith personally spoken or attempted to speak with the other party in an effort to resolve the dispute without court action. So your certification must also identify the date and time of any conference or attempts to confer. So we can no longer use those form letters where we state this is our good faith attempt to resolve the discovery dispute. We now actually have to pick up the phone and try to reach out to the other side. The scope of discovery. The proportionality language that I have here on this slide previously existed under the motion for a protective order section. Now it has its own subsection, but the basis for the rule has stayed the same. However, the court can now limit discovery on a motion, or it can do so sua sponte. Moving on now to talk about supplementing discovery. This language has changed as well. A party is now under a duty to seasonally supplement or correct its disclosure or a prior response if the party learns that in some material respect the disclosure or response is incomplete or incorrect, and if the additional or corrective information has not otherwise been made known to the other parties during the discovery process or in writing. The former rule had language about a knowing concealment, so you had to provide or supplement your discovery responses if failing to do so would amount to, in substance, a knowing concealment. And basically, the committee and the court thought that that test was too difficult to actually apply and administer, so that's the basis for this new change. Let's see, moving on. Another change is that parties may rely on another party's discovery. So when I talked about that example of the plaintiff serving various defendants, if defendant 1 has served the plaintiff with interrogatories and the plaintiff answered, the other 2, 3, or 4 defendants may rely on the plaintiff's answers to defendant 1's interrogatory answers. Now the catch is, if that defendant 1 is later dismissed from the case, the plaintiff does not have a duty to supplement their discovery answers and responses. So you'll want to be careful about that if you are intending to rely on those documents. Protective orders. There's a new remedy in this section. The court can now allocate expenses. It incorporates the proportionality language that I mentioned before, as well as that new requirement of having to personally speak with the other side before proceeding with a motion for a protective order. And now the court may award expenses if a protective order is granted, or if the disclosure or requested discovery is provided after the motion was filed. So now the rule clearly provides for this relief. The discovery of experts. So the disclosure of experts happens first, then discovery happens. A deposition of an expert can only take place after that expert's report has been provided. Drafts of reports are not discoverable, and any communication between the attorney and the expert witness is protected, except for the following: the expert's compensation, the identification of any facts and data that the expert is relying on, and the assumptions made by the expert when producing the report. The expert must supplement their report no later than 30 days before trial. Moving on to interrogatories. Interrogatories must now be provided in an electronic word processing format. So a best practice would be to not only send them in the word processing format, but to also send them in a PDF form so that you have a record of what exactly was sent to the other side. Whenever you answer subject to an objection, you must state the extent to which the interrogatory is not being answered. This was a change that the committee and the court implemented because they wanted to cut down on frivolous discovery disputes. So now, hopefully, the parties will actually know if there's something to even fight about if a party does make an objection. And any discrete subpart of a non-pattern interrogatory counts against the limit of the 30 interrogatories. And my colleague Maggie here will be discussing that in more detail with you in the next part of our presentation. Regarding requests for production of documents, objections must be specific, of course. And the biggest change here is that, like the interrogatories, whenever you make an objection or make an objection and then subject to that objection answer, you have to state to the extent to which responsive materials are not being produced. And again, it's the same reason to cut down on frivolous discovery disputes. Moving on to depositions. Objections must be stated concisely in a non-argumentative and non-suggestive manner. So you may only instruct someone not to answer to preserve a privilege, to enforce a court-ordered protection, or to present a motion to terminate or limit the deposition. The following are new consequences. So if you fail to make your initial disclosure requirements, a party may file a motion to compel. The court may also grant a motion to compel without a hearing if no timely resistance has been filed. Additionally, the court may award attorney's fees and expenses if a party fails to participate in the discovery conference or fails to participate in the discovery plan. The usual consequences for failing to comply with the discovery requirements still exist, such as if you don't do so, you may be held in contempt, your information may be stricken from being used, etc. So with that, I'm going to turn it over to my colleague to talk about, Maggie, to talk about the expedited civil action track.
Thank you, Kelsey. I will be talking about the expedited civil action track, as Kelsey mentioned. The first thing I want to mention is that really the purpose of this new track, which you'll see located at Rule 1.281 in your new Rules of Civil Procedure, the purpose of this new track is to preserve and hopefully increase the number of jury trials and sort of ensure that litigants aren't priced out of the system. And this is really beneficial to us as young attorneys, if there are young attorneys out there listening, because we don't get the opportunity necessarily to try many jury trials right off the bat, and this will create an opportunity perhaps for us to get involved in those earlier on. So first, to be eligible to enter into this expedited civil action track, the sole relief sought must be a money judgment. There are cases in which an equity action can go through this system. However, there must be agreement by both parties in order to enter into the track. There is a $75,000 limit on recovery, and this includes all claims other than compulsory counterclaims for all damages by or against any one party. This includes everything, including attorney's fees, but does not include things such as costs and post-filing interest. Further, it is the plaintiff's option whether to elect to opt into the system or not. So it's really plaintiff's decision. Therefore, that's kind of the disadvantage if you're a defense attorney. Your client can be brought into one of these actions really without any say by you, and defendants are not allowed to opt out. Once plaintiffs opt in, they must file a certification form, and this form can be found at Rule 1.1901, Form number 16. And on the next slide, I'll show an example of the form. But once that's filed, the plaintiff is bound by the $75,000 limit unless circumstances change substantially, or if a compulsory counterclaim is filed, which is in excess of $75,000, or if the parties stipulate to the expedited track without the ceiling of the $75,000. And like I said, again, the defendants are not allowed to opt out of this track. This is an example of the form found at Rule 1.1901, Form number 16. And this sort of explains to the plaintiff, it takes care of a lot of the informed consent issues, actually, with entering into this track. As you'll see, if you read through numbers 1 through 4 on the form, it requires the plaintiff to understand that they are entering into this track, understand that they are bound to no more than $75,000 in damages, and this will be filed with the court, so you'll have a complete record of this. But it would be best practice for those plaintiff's attorneys out there to probably obtain some additional informed consent, perhaps have something for your file that the plaintiff has signed, affirming that they have agreed to enter into something like this. So here's what I was talking about. This is the portion of the form that you should really focus in on that takes care of the informed consent issue, and make sure your clients are reading over this very carefully. Next, with discovery in the expedited civil actions, initial disclosures will still be required as in all other civil cases, so refer back to the rules that Kelsey was talking about earlier. Discovery must be completed no later than 60 days before trial, and there are limits per side. So the committee came up with a term, side, which will refer to all litigants with generally common interest in the litigation. So plaintiffs and defendants will be kind of grouped together in that sense, even if you have more than one plaintiff or more than one defendant. Each side may serve no more than 10 interrogatories, 10 requests for production of documents, and 10 requests for admissions on any other side. And this, as you'll see, does exclude requests for admissions for genuineness of documents to be offered at trial. This is where I'll talk about the pattern discovery requests that Kelsey mentioned earlier. The pattern discovery requests will be something that the Supreme Court will release various sets of discovery requests for particular types of cases. So here, the pattern discovery request will count as one interrogatory per request. So each subpart of a non-pattern request will count as one interrogatory, whereas in the pattern interrogatories, you can have subparts that won't necessarily count toward your 10 interrogatories. So take that into account when you're drafting discovery in these expedited actions. Each party, each side may take one deposition of each party in the case, and there can be 2 depositions taken of non-parties in the expedited civil actions. Further, there can be no more than 1 expert per side except by agreement of the parties or for a showing of good cause. And you'll notice that a lot of these amendments and these changes are not set in stone. You can always show good cause for why the court should deviate from these rules. So just remember that these aren't set in stone by any means. As far as motions go in the expedited civil actions, motions to dismiss will remain the same. They are permitted. The one thing to note is that they do not eliminate or postpone the pleading or initial disclosure requirements. Your timelines are still set in stone, and that's the purpose of this expedited civil action, is to keep the ball rolling. So none of these deviation tactics will work anymore. Motions for summary judgment are sort of the biggest change with the expedited civil action track. Note that any side can file no more than 1 motion for summary judgment. So remember that limitation on sides. When there are more than 1 plaintiff or more than 1 defendant, be sure to be conferring within your own side as to motions for summary judgment. Each motion for summary judgment may include more than 1 ground. However, the grounds are very limited. You'll see that the limited grounds are to collect an open account or liquidated debt, to establish indemnity obligation, to assert immunity defense for failure to comply with Iowa Code 668.11 or other disclosure deadlines, for failure to provide notice or exhaust remedies, or to assert any other affirmative defense. You'll see that in the expedited civil action track, you can no longer use motions for summary judgment for the old. The party has failed to meet all the elements of its claim. That's simply no longer a ground for a motion for summary judgment in this track. And further, the motions for summary judgment must be filed no later than 90 days before trial. In the expedited civil action track, you must also make a timely jury demand if you want the case to be heard to a jury. Otherwise, all cases will be tried to the court. Trial will be set within 1 year of filing, and this date is flexible within a week of the same date for which the trial was originally set. So you'll see that the courts aren't going to be very flexible as far as moving around months or weeks. You can ask for another date during that same week, but they're really going to try to buckle down on that. As far as pretrial submissions go, those are required under Rule 1.500 sub 3 and Rule 23.5, and Kelsey mentioned both of these earlier. The only difference with pretrial submissions under the expedited civil actions is that one jointly proposed set of jury instructions and verdict forms will be required to be filed. Now, this doesn't necessarily mean that the sides have to agree as to all jury instructions or verdict forms, but you do need to submit that jointly proposed set. If you do have any objections to any of the jury instructions or verdict forms, you may object, but you must propose alternative instructions or verdict forms along with those proposed set of jury instructions. The expedited civil jury trial will be limited to a 6-person jury, which will be selected from a panel of 12. Each side will be allowed 3 strikes, and the jury will have a 3-hour deliberation time to reach a unanimous verdict. However, after 3 hours, the court will allow a 5-person majority verdict. As far as an expedited non-jury trial, the court may dispense with the findings of fact and conclusions of law and render a judgment on a general verdict, special verdicts, or answers to interrogatories that are accompanied by legal instructions that would be used if the action were being tried to a jury. So in that case, the judge, although your case may not be tried to a jury, the judge may require that you still submit those jointly proposed set of jury instructions and verdict forms so that the court can render a verdict based on those forms and instructions. The court will indicate which instructions it is following and like I said, can choose whether or not to render its verdict in a verdict form that you've provided. So like I said, this would require the parties to comply with the pretrial submission requirements of 1.281 sub 4 sub C. The expedited civil actions will be subject to a time limit at trial. This time limit is 2 business days. That's the goal. And each side is given 6 hours, which includes jury selection, opening statements, evidence and examination, both direct and cross, and closing argument. The time limit does not include, however, objections, bench conferences, or challenges for cause to a juror. The committee anticipates that each side will track the other side's time, so we're not really sure how this will play out necessarily. There are quite a few kinks to be worked out, I think, as far as the timing goes, but once again, since this is a brand new thing, we will just see how it evolves. Further, the court does have the ability to extend these time limits, so once again, these are not set in stone, as long as you can show good cause for the reason why your time limit should be extended. There are a few changes to the evidentiary rules in the expedited civil actions. First of all, the courts are going to recommend that the parties should stipulate to factual and evidentiary matters wherever possible, but there are a few special evidentiary rules. First of all, business records and like documents may be admitted without the testimony or certification of a custodian if the party offering the document gave notice at least 90 days before trial and the document on its face appears to be genuine and what it purports to be. Please note that this does not eliminate any hearsay or relevance objections that may come up for a document, but only eliminates the certification requirement. And the purpose of this rule is really to reduce the cost of trial by streamlining this process of getting these documents admitted. The second special evidentiary rule is that a healthcare provider who treated the claimant may provide a written statement according to a standard form in lieu of testifying in court by way of an evidentiary deposition, or by way of evidentiary deposition, excuse me. The purpose of this rule is that obtaining healthcare professional testimony has really been a barrier to people having access to the justice system, and so this is really a way to eliminate further expense from litigation. So I'll talk further about that care provider statement in lieu of testimony. There's a form that can be found at Rule 1.1901, Form 19. And this form will provide standard questions as to injuries sustained, treatment necessitated, restrictions or limitations on the claimant as a result of those injuries, things of that nature. The statement will also disclose communications that the healthcare provider has had with claimant's counsel and must be provided to all other parties at least 150 days before trial. So that's pretty early on in this expedited civil track. Healthcare providers may still be deposed, but that will be at the expense of the party who desires to take the deposition. And on this slide, I'm showing you an example of that healthcare provider statement in lieu of testimony. As you can see, it's a pretty standardized form and should be fairly simple to have your healthcare provider fill out. And once again, can be found at Rule 1.1901, Form number 19. And here's the example of the attorney certificate, which requires that the attorney certify, the attorney for that party who is using that healthcare provider certify the statement made by the healthcare provider. So just remember to fill this out in addition if you're using that healthcare provider statement. Finally, a few miscellaneous items with regard to the expedited civil actions. There is a limitation on issue and claim preclusion. So judgments or orders in an expedited civil action may not be relied on to establish claim preclusion or issue preclusion unless the party seeking to rely on the judgment or order was either a party or in privity with a party in the expedited civil action. And finally, it's important to note that the jury in your expedited civil actions will not be informed of the $75,000 cap on damages. So the jury could come back with a higher award of damages, but your takeaway will be limited to $75,000. So with that, we will open it up to any questions or discussion that might need to occur.
It looks like we have a few questions. I'm sending you the first one right now. Kelsey, you should have received the first one.
Okay, we're looking for it right now.
Okay, it should pop up under your chat area.
The question is, can the lawyer fill out the healthcare provider statement so long as the healthcare provider signs the statement?
It would appear that yes, that can be the case. The healthcare provider must at least sign the statement, and like I said, the attorney must also certify the statement afterward. So it would make sense that the attorney could fill out the form as long as the healthcare provider signs off on that. But you might notice that on that healthcare provider form, there will be a lot of healthcare provider specific information required. So it may be best practice to have your healthcare provider fill that out for you.
Or like typical, whenever a party signs off on interrogatories, you'll just want to emphasize to that healthcare provider that they have the obligation to make sure that all of the information is accurate and truthful. The next question is, if the jury doesn't know of the $75,000 cap and returns a verdict of $150,000, will the client line up to sue the plaintiff's attorney?
And that is a risk, but you'll have to notice that when you enter into the expedited civil track, remember you are required to file that certification form, and presumably your client has read that form, signed that form, and that form has been filed with the court. That's why I also said you may want to obtain some additional informed consent from your client to have in your file, to have some document that they have also signed in addition to that certification form that protects you from anything like this, because they need to understand that entering into this track limits them severely and limits them to that $75,000.
Right. The next question is, what constitutes a discrete subpart of an interrogatory?
So a discrete subpart in the interrogatories, which I talked about with the pattern and non-pattern discovery requests, a discrete subpart is when you have the general interrogatory and then you have subparts A, B, C through Z. And typically when you have the non-pattern requests, those subparts, those discrete subparts, will count against your number of interrogatories, especially in the expedited civil action. But if you have a pattern discovery request that has those subparts or discrete subparts, those will not count against your 10 that you are allowed under the expedited civil action. And I assume the same will kind of go, there is case law out there already saying that discrete subparts, I think from Judge Bennett in fact, saying that discrete subparts can count against your number of interrogatories anyway. So that shouldn't change in normal discovery.
Maggie, the next question, I think we may need to back up here because the next question is asking what is a pattern discovery. So could you explain that a little bit?
Yes. As I touched on before, pattern discovery requests will be something that the Supreme Court is planning on releasing, these pattern discovery requests that you can use as kind of forms in specific types of cases. So they will tailor these pattern discovery requests to different types of cases, and you'll be able to kind of just throw those into your discovery. Kind of reduces your workload as you're serving discovery, if that makes sense.
The next question is asking if you are aware of, has anyone considered that only plaintiffs that are bill collectors may be the plaintiffs that are using the expedited track?
Yes, and I've attended a few other CLEs on this particular topic as well, the expedited civil rules and the discovery amendments, and people contemplated that there will not be a lot of plaintiffs who agree to enter into this track other than people who are collecting on contracts or those who are collecting a debt, because it's just simply a system where a lot of plaintiffs believe that their cases, whether merited or not, are worth more than $75,000. So it's not going to be a heavily used system, I don't think, but once again, it's one of those things we'll have to kind of see where this goes.
The next question is, may the jury be asked of its knowledge of any verdict limit?
I would say that I am uncertain of that answer, to be truthful, but I would add that it's probably likely that the jury cannot be asked that question, because that would imply that there is some verdict limit. Otherwise, you wouldn't be asking that question. So,
if the jury sends a question to the judge about any cap, will this be an automatic ground for a mistrial?
That's another one that I am uncertain of the answer on that. You know, these rules were contemplated by a panel of civil procedure professors, judges, and attorneys, and so all of these kind of little questions have not really been contemplated yet, and we'll just kind of have to see where the courts take these.
In fact, we've even heard that the committee that formulated these rules, they weren't even always in agreement on how these rules should be put into practice. So that's why we'll kind of have to wait and see how some of these kinks unfold with time. And the next question is the review of these rules continuing as they are used or not being used?
I would assume yes. The committee seems as though they are going to be monitoring these rules as we progress, and it'll kind of be an ongoing process, as with any amendment or rule, or new rule, I mean, where the courts still need to interpret these, they still need to put them into practice, and we'll work out the kinks as we go.
The next question is there a requirement that the defendants, such as doctors and experts, file a form with their opinions as well?
I'm not entirely certain what this question means, but I assume is it referring to the expert
disclosures? Maybe? There's not a form document that I'm aware of, but the information that I have on that slide that must be provided in their expert report. I'm looking at this next question here, so we just ask for a moment. Okay, the question is, if there is a car accident with a dispute over the reduction of value of the car, and in which there is a soft tissue injury, how can we use the expedited rules on this limited damages case when we need both a car dealer expert and a doctor's opinion? Say the case has a value of less than $30,000.
So I believe this is a perfect case for the expedited civil track. It gets your litigants into court without having to pay a great deal in costs and expenses. I see where you're going with this is that the expedited civil track limits you to one expert per side. And like I said earlier, these rules aren't set in stone necessarily. Each rule can be altered for good cause shown. So if you have good cause such as this where you definitely do need two experts, I would say you ask the court for permission to use two experts in that case, because it seems as though the courts are open to adding more.
When good cause exists.
When good cause exists. So.
All right, give us another moment while we look for the next question. The next question is, do the expedited rules impact the current requirement for expert certification to accompany malpractice filings?
And this is another thing where, I mean, we'll have to see how it plays out. This wasn't specifically addressed. I know that the general, other than any deviations I listed, the general Iowa Rules of Civil Procedure do apply to the expedited track. So.
The next question is asking for the expedited track, will there be a shot clock, so to speak, so that the parties know how much time they have left?
So this is another thing that I assume they will work out once we get into the heat of it, but the committee anticipates that the other side will time the other side's trial as it goes. So if the other side wants to provide a shot clock, so to speak, then that would be their prerogative. But I don't know that that's going to be something that will be implemented. So.